right?
I was taken aback when I heard it because I couldn't. I tried to step back from the emotion of being invested in this bill and tried to figure out how someone could have this perspective on it, and I'm at a loss.
Welcome back, guys, to Cases and Cocktails. This is episode number 25. Today, I'm here with my beautiful wife, Janice. How are you?
Amazing. How are you?
I'm fantastic. Can you believe we made it through 25 of these things?
No, yeah. I didn't think it'd last.
I didn't either. We're here today. We'll talk a little bit about me and you. We want to talk a little bit about something that we recently did there at the legislature. Is that cool?
Yep. Sounds good.
Fantastic. Before we do that, let's talk a little bit. We've got a drink because it is Cases and Cocktails. It's a little pink. That's all right. Here we go. What is it?
It's a Coconut Tequila Cooler. It's got the Ocho tequila that you like.
Okay.
Coconut water, lime juice, and agave.
Nice. That is fantastic. You ready?
Mm-hmm.
All right. Here we go.
That's strong.
She said strong. That's good. That's good. You know, the problem I have is a lot of times my drinks.
It's got too much pretty stuff on top.
Yeah, it's got
in the way of you drinking it.
It's got a lot of stuff in it. It's good though. It's good.
Here.
What? Oh, nice. That'll probably make it easier, huh?
Don't drink that.
Don't drink. What is that, by the way?
It's a lime.
That's a
Maybe.
lime?
I don't know. I'll ask Fernanda.
Especially,
it looks like a lime.
All right.
Like dried.
Dried lime.
Yes.
Okay. Well, we had an opportunity recently to go do something we'd never done before. We got an opportunity to go and testify in the legislature for a bill that was being proposed.
Mm-hmm. In the Senate, yeah.
And we actually testified in front of the Senate committee for that was hearing that bill, I guess. Is that right?
Yep.
Right. Tell me what your thoughts were.
It was exciting. I had personally never seen any of that happen at the Capitol, and I thought it was really cool. The kids lately have been griping a lot about going to the Capitol for whatever reason, and so, of course, we got invited to go down there, and it was really exciting to go down there and see the way that it plays out, right? That they have all these different groups of senators on the committees in different rooms. You go in and you sign up on a computer screen. You walk into the room and wait for your bill to be called and read. And then you get to go up there. We were invited by Senator Paxton. So the invited guests got to speak first, and then they open it up to the public, and anyone can come up and talk. And I thought it was a really cool experience to go do that. I want to do that more.
Yeah, I thought it was really interesting to go and kind of see how it happens, but then to also kind of participate in it was really neat.
I wish I'd seen it a little bit more before we went. I feel like we were sitting in there for 5 minutes and it was our turn.
Yeah, I think we were one of the first ones to go. We didn't have a lot of examples to follow, I guess.
Yeah.
Interestingly enough, too, by the way, and I didn't know this when we got asked to do this, they limit you. You're limited to 2 minutes.
Right.
And that's
you're supposed to be limited to 2 minutes. And I realized very quickly that they had not set the timer when it was your turn.
Right.
I think one person went before you.
Right.
And then it was you. And I remember thinking to myself, I thought it was 2 minutes, and I looked around and I was like, they didn't set a timer. They'll do that once, and they won't make that mistake again.
For me, I was trying to think too. 2 minutes. We do. You do opening statements all the time, and the court's like, give me a brief opening statement, and 15 minutes later, I'm clipping, through all the things, and the court's kind of looking at me, which is pretty typical. I try to keep it brief, but typically 10, 15 minutes to
say hello
to kind of get the whole thing out. And all I could think was, for me to just to get my name out, introduce myself, and let everyone know why I'm here. 2 minutes, pretty much. That's
right.
pretty much it. I did. It was very, the committee is sitting around you, and you're kind of sort of in the middle here.
Yeah.
And so there's a bunch of humans who, by the way, are elected officials, and probably way cooler than I'll ever be. And so they're all sitting there, and then behind them they have their staff, and then you're sort of at this table. So you're trying to engage. When you're talking to a judge, there's one human,
Right?
And you're kind of looking directly at that human, and you're talking at that person, right? And you can make some gestures and that sort of stuff, but for the most part, it's a one-on-one conversation.
You only need to keep one person's focus, not an entire committee.
Right, and you're trying to kind of gauge, people are they engaging back? Are they listening? Could they care less? Right, trying to get some input, from the audience, and so it was a little nerve-wracking. I don't know that I've ever engaged that many people on a small scale like that. Does it make sense? So I've done like presentations like CLE and that sort of stuff. So you got a big room.
It was more like jury trial, right?
Yeah. I didn't think about it that way. It is kind of like, there was probably 15 people.
Yeah.
So it's pretty much like a jury. The jury boxes are like a little tight.
And they're off to the side. So you're doing your thing here and they're watching but you're not really
engaging them directly.
The entire time, right?
Yeah.
Unless you're making oral arguments, but it was nerve wracking, and they were sitting up there, and I remember looking and trying to make eye contact with everyone. I'm like, is this too much? Is this too little?
Right.
But I was surprised, and I don't know how this is going to come off, but I was surprised how engaged everyone was.
Right.
Sometimes you're in a courtroom, you feel like you're doing something really important, you're not sure that anyone's paying attention to what you're saying. And there, I feel like everyone was very engaged. They were paying attention. When I went to look at people to make eye contact, they were already looking at me.
Yeah, no, I felt the same way. Like I felt like they were intently listening. You could see them nodding or shaking their heads, making notes, and doing stuff. It was interesting. It was very interesting.
And it went quick.
It went, 2 minutes. It's bam, 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 and it's 2 minutes, and you're done. It's really interesting. It was interesting to me to be up there and to see how all that kind of plays out. It's also interesting, sort of some of the things that happen at the legislature, which I guess I was just unaware of. I had an opportunity to be asked to go talk to a senator back in his office. You just walk back there and you're like, hey, I'm here to talk to you about X, Y, and Z. And they're like, okay. And like their staff kind of comes out and vets you, right? But, for the most part, that's how this happens. Like people are just going up and down the hallways, going to offices, trying to do so. I was just unaware of it. And maybe that makes me naive, I guess. I'm sorry, or ignorant, I guess. I don't know.
We hadn't done it before.
No, I hadn't done it before, but it was fun. It was fun.
You want to talk a little bit about what we talked about?
Well, yeah, we can. So we were there. Robert Garza has got a bill that he's trying to pass, and it's being sponsored by Senator Paxton. She's senator up there for the Collin County area, and the law that they're trying to pass is an amendment to an existing law, right? So currently, there's a there's a law against interference of custodial time, right?
Correct.
And right now, that law, as the statute as it's set out, it currently is it basically says it's a state jail felony, right? To
Custodial interference.
Custodial interference for possession access. The problem is it's a state jail felony, and then it has to be picked up by the DA's office. And most of the time, that stuff doesn't get picked up by the DA's office. Most of the time, it's handled in family court.
For it to go straight to a state jail felony, I think, is the problem from what I've experienced for both law enforcement and the state once someone goes and brings the file to them. And in the way that the current penal code statute is written, it's only the non-custodial parent that can be in violation of this law. Right. So the custodial parent can't be in violation. They can't be charged with custodial interference with the way it's currently written. But when you tell law enforcement, hey, they're violating the visitation,
court order,
or
right.
a court order, two things. One, you have to have law enforcement read a court order and understand what it says, but also for them then to start putting together an investigation on something like that and feel like it's enough to bring to the state as a felony.
Right.
It's a lot.
It is a lot, and it's a law that, like I said, it exists. So this already exists, and
I've seen it used once.
Right.
Ever.
What this new law is doing is amending that. It's amending that statute, and it's doing a couple of things. First and foremost, it talks about it removes these designations of custodial and non-custodial parent.
Right.
And we've been doing this 15 years, and it's not unusual. And I'm gonna small sidetrack, and then we'll talk about it later here in a second. But
Okay.
Small sidetrack. There's people have all sorts of names for parents in custody cases, right?
Right.
Primary parent, custodial parent, non-custodial parent. All these different labels. And that's what it is. It's labels. I talk to my clients all the time. I'm like, look, this is a label, right? That's all it is. The rights and duties actually matter, right? But
It's the meat that matters, right?
The name that's up there doesn't matter at all, right? Call yourself whatever you want. But what this law does, and we'll get to, there's apparently that's a whole ordeal, by the way.
I had no idea.
But anyway, with that being said, this law gets rid of those designations and just uses the word parent, a parent, right? Because that's what we're talking about. We're talking about parents, and parents, if they're interfering with, or custodial interfering with custody, then they can be charged under this statute. And again, this is the penal code. This is not family code. This is the penal code, but it plays with what we're doing. The other thing that it does is, and I think this goes to your point, which is, oftentimes the current statute's not used because they're like, you screwed up one time and now it's a state jail felony.
Right.
And I think law enforcement, I think even district attorneys are likely a little hesitant
to start
charging people with
bringing
felonies.
up parents with felonies for what could be a mistake.
Could be a mistake. There's a lot of reasons, and I think that's important. But what this law does, the proposed amendment to the law, this bill, I guess, is it basically says the first time that officer comes out and one parent is engaging in custodial interference, and let's just be very clear, that's when one parent is denying the other parent possession and access based on a court order.
Correct.
That's it. Okay. That happens. Officer can read the court order, say, look, it is this parent's time, and give the parent that is denying possession access a Class C misdemeanor, traffic ticket.
A citation. Yep.
Citation. Get that, and turn the kid over to the parent that's supposed to have the kid at that time. And so that happens. That's on the first offense. Second offense does the same thing.
Yep.
Then on the third offense, it's a state jail felony.
Right. So it gives the officers something that they can actually do in the moment that will hopefully cure the problem.
Right.
Because the other thing is, okay, with the way that it's currently written, the officers come out and they write reports and they keep track of it. Okay, fine. But who knows how much time is going by in the meantime, and what officer comes out and who communicates with whom and what type of track record we have. And ultimately, what we're trying to prevent is the custodial interference and trying to prevent parents from losing the relationship with their children because one parent is withholding.
Right.
And this allows the officer to come out, see it, say something, and it's just a ticket.
Right.
Write a ticket. And for some people, that's going to be it. It's going to be enough.
Right.
They're going to say, okay, it's not just a court order. It's kind of like the law too.
Right.
So
there's a punishment here, right?
Right.
Yeah.
That isn't this other person has to go hire a lawyer and go file an enforcement, because they could say, well, I know, my ex isn't going to be able to afford to go do that, or can't take the time off of work or whatever it might be. Yeah. Here, there's an immediate ramification for it. It's a ticket. It's not huge, but that, I think, is going to be enough for a lot of these cases, and it's going to prevent it from escalating and continuing.
Right.
They come out, it happens again, you get another ticket. Now we've got a track record. Now we're talking felony.
And on top of that, it's a traffic ticket.
Right.
And let me say this: the idea and the purpose behind it is to effectuate navigating this issue on the ground. So you're giving the officer the ability to navigate this on the ground, do stuff. You're still likely, there's a greater than zero chance you may end up in court on the family side.
Sure.
If it continues to happen, you'll have to do enforcement. You may have to do a modification, that sort of stuff. And I know that there's some of the opponents to this said, well, it's not fair. These people are going to have criminal charges, and there may be reasons why, and all this other stuff. And I don't discount
reasons
them.
why they're denying visitation.
Yeah.
Well, I mean, I think we talk about this regularly with clients. If there's a reason to be denying, then you need to go into court and change the order.
Right. You need to do something proactively. And there's always going to be those instances where you found out 15 minutes before you're supposed to exchange little John. But what's interesting about that,
you can bring that same evidence into the criminal court, judge.
Right. And there's a much higher burden on the criminal side than there is on the family side. The criminal side is beyond a reasonable doubt. Even at the Class C misdemeanor, it's still beyond a reasonable doubt. You go to court in family court, and it's not nearly that, right? It's preponderance of the evidence. And so at some point, right, you've got a situation where you're still going to be able to address those situations where little Johnny or little Susie need to be protected in the last minute or whatever it is. And more importantly, if little Johnny or Susie need to be protected, they're in imminent harm.
Then you protect him.
Safety, welfare.
You should probably be calling the police.
You should be calling the police. You should also be calling your attorney. You should be getting a temporary restraining order.
Right, 100%.
Right. That's what a TRO is for, irreparable harm, and that's what it's for.
What we don't want is individuals going out and doing this on their own and saying, well, there's a danger or this isn't a good idea or whatever reason, and not having to go and prove that in a courtroom.
Right.
We've got a court order that was signed by a judge. It's deemed that this schedule is in the best interest of the kids. And if you disagree with that or you think that circumstances have changed, then it should be your burden then to go into court and change it and not unilaterally be a vigilante and decide what rules you are and aren't going to follow.
Well, and it's not just follow the rules. It's following a court order, right? The judge, that's the whole idea behind it. And the entire system's kind of predicated that, we get a judge to sign this piece of paper and this is what y'all are supposed to do, period. Right, that's it. And if you don't want to do it, that's fine, but you got to go back and get a judge to do it. What's interesting about that, and I'm going to use that to poorly transition into something, but apparently those concepts that we just talked about are not widely understood, not only by parents, right? Y'all, right? People that are going through this. They're not always understood by attorneys. I won't get into any names or anything. But what's more important and something that I got to witness, apparently also not well understood by legislatures or legislators, right? I got to see an exchange. I think you and I both got to see an exchange on the Senate floor. This same bill had come up for a reading and to be passed through the Senate. And I got to see an exchange. And during this exchange between two senators, one was Senator Paxton, and the other was a senator who seemed to have some questions about the bill. In
opposition of the bill.
It seemed like she might be in opposition. I was going to be nice, but this senator was using words that were completely not correct, but also highly misinformed. I don't know how else to say that, right?
I was taken aback when I heard it because I couldn't. I tried to step back from the emotion of being invested in this bill and tried to figure out how someone could have this perspective on it, and I'm at a loss.
The thing, I think the most glaring issue was when the senator that was opposing this on the Senate floor made a statement that we were talking about the use of the words custodial and non-custodial parent. And let me...
The opposition to this amendment was that we were going to remove the custodial and non-custodial designations and make it to where either parent could be subject to a criminal penalty for custodial interference. And I didn't think that anyone was actually opposed to removing that designation. I kind of thought it was a mistake that it got put in there to begin with.
Right. It was breathtaking. She made a statement on the Senate floor that we all know that non-custodial parents have been proven to be the bad parent,
right,
or not the good parent by the court. That's why they're the non-custodial, and the custodial parents are the good parents.
They're the ones that were chosen because they are the better parent.
And
I've never had that perspective.
My mind melted a little bit when I heard it. I don't know. I mean, for those at home that are playing along, a custodial parent and a non-custodial parent, those are designations that are, you find that language in the family code. You also find that language used a lot of times in the Office of the Attorney General.
When dealing with child support.
Child support, Title 4D courts use that. The OAG will often, the person who's paying child support is listed as the NCP, which is non-custodial parent. And the other parent is the CP, and the custodial parent. Those are literally just designations that are labels. I'm not sure, and I'm sure there is someone that is smarter than me that will tell me I'm wrong, but I don't believe they actually have a basis in determining rights or duties. We use the word conservatorship.
Right.
And you have joint managing conservators, and you have sole managing conservators and possessory conservators. But this idea that non-custodial or custodial parent or primary parent, these are just labels.
They are just labels, and they're not labels that are in the court order.
Right. And it was breathtaking to me to hear that there was this ideology that non-custodial parents were all bad parents.
And that the thing that took it one step further that gives me even more pause or a cause for concern is that she was implying that as the custodial parent, as the better parent,
right?
Her words, not mine. As the better parent, that better parent is the better parent for a reason, was chosen by the court or by agreement as the better parent. And if that better parent thinks that the child should be doing something else or believes that the order should be violated, basically that the better parent should be the one making that decision. And I was speechless.
It's, this idea that
that's dangerous.
It is dangerous, but that I guess what's dangerous is that this is a concept that was being sort of articulated by an educated, publicly elected official, and as if it was just common knowledge, as if this is the way it was. And so I guess for me, it was a really interesting juxtaposition to be in the weeds and the granularity of working on one particular piece of statute and doing this thing and having this sort of really in-depth, conversation about how the legislature and the statutes play, the language involved. And then this high level sort of just concept that is breathtakingly wrong, one, but two, being said as if it's just the truth.
And people don't know.
Right, 100%.
Right? A lot of people watching and paying attention and that vote, they hear this person speaking, and because of this person's position, they have a high regard for what that person says and this person just missed it completely.
Interestingly enough, the other thing too, everyone during that exchange, anyway, I won't say everyone, during that exchange, people often talked about agreements and paperwork and stuff like that. Make no mistake about it, guys. We're talking about a divorce decree or a custody order that's signed by a judge.
Right.
These are final orders. These are things that have been adjudicated, written down. The parties are ordered by the court to follow them. Period.
And it's all that these parties have.
Right.
It's all that they have to go by to know who decides what with their kids, who gets to see them and when. And if we've decided that this isn't the way to do it, fine. Let's figure out a better way. Right. But we can't just ignore a court order. Right. people spend an exorbitant amount of time, money, and energy to get these orders, and then for them to just be thrown out the window because of a made-up label that's not even in the order is baffling.
Yeah, it was a lot. One of the other things, there was this entire exchange that sort of occurred about a hypothetical, and this hypothetical was, if one parent wanted the kids to not go to the other parent because a favorite relative was coming into town, and is that interference and all this other stuff, and I don't know.
And the questions were posed to Senator Paxton, and Senator Paxton did a fabulous job of trying to basically say, well, if it's interference, that's up to someone else to decide, but that's not where we are here.
Right, and the problem is that there was sort of this attempt to extrapolate or sort of extend the language that's in the order about interfering, custodial interference, and is asking little Johnny or little Susie not to go to the other parent. Is that custodial interference and all this other stuff? And the truth of the matter is,
yes, it's interference. If you are asking your child if they want to go do something other than go to the other parent's home on the other parent's period of possession, yes. And I know it's a hot sports opinion, but yes, that's interference. That's literally the definition of it. You're interfering with your child going to the parent that they're supposed to go to. What else is interference?
No, I agree. And this is the type of interference that we see all the time. This is the type of actions that we see all the time in custody cases, particularly parental alienation cases or refuse and resist cases or psychological maltreatment cases, where one parent is trying to influence the children to not go to the other parent. See it all the time. But the problem is that the extrapolation of this bill to that is logically fallible. And it doesn't make sense. The bill is very clear. If you deny the other person possession access based on the court order, then you're subject to this penal code.
Correct.
Right. And so you're going to get a ticket.
Right.
That's what you're going to get. Second time you get a ticket, third time it's a stage of a felony. That bill is not designed to keep mom or dad or a parent from trying to influence little Johnny or little Susie.
Right.
That's still going to happen.
Right.
And that's going to be taken care of on the family side. That behavior is a litigated issue that often occurs in custody cases, sometimes because it's being done directly, it's being done as a strategy, as a way to manipulate the children. Sometimes it's done inadvertently. Sometimes it's done passive aggressively. Sometimes it's just done by mistake, and it happens. But those are things that get litigated over here. This idea, though, that we're going to throw people in jail for telling little Johnny or Susie, hey, do you want to stay home with me to see your favorite uncle or whatever it is, that's not what we're talking about.
If Johnny doesn't go.
If Johnny doesn't go, then you're in trouble. Right, 100%.
But the question isn't even based on.
Right.
It's so far removed, and there were so many issues with the question, and this person continued to press that question.
Over
and when
and over and
Senator
over.
Paxton tried to say, well, that's not really a question for this.
Right.
That's not where we are here. It just kept getting pushed aggressively.
One of the other things I think that bears mentioning as well is that in 99%, I don't know, it's a very high number of custody orders. I imagine there are some that miss this language for whatever reason, but
in Texas,
in Texas,
man, I've seen some from out of state, and I don't know what they're doing.
Of course, we're talking about Texas, but most custody orders in Texas, these are documents that have been drafted, signed by a judge. Most of them are going to say the following: they're going to say that mom or dad or the parents, they can literally agree to whatever they want
before the possession schedule. Before we say who gets the kids when, there's language that says they can do whatever they want as long as they have an agreement.
As long as they have an agreement.
But if there isn't an agreement, here is the very detailed order about every minute of this child's life and where they're going to be at that minute.
Right. And so the parties always have the ability, parents always have the ability to come to agreements. And that's great. The issue is that, they're literally holding themselves out in public as I didn't get along with this person. We can't come to agreements. Right. So, Judge, I need you to write down what we're supposed to do.
Right.
And so anyway, my point is, You have the ability to come to agreements. So that solves one of these things. The other is this. In every order, it talks about not interfering with custody.
Right.
There's like standard language in there that says, the parents aren't supposed to interfere
in
with
caps or in bold.
Right. And so it's,
right.
This idea that everyone's having not everyone. Some people are having a meltdown about enforcing a law that enforcing court orders, and which is fine. But I was taken aback by that. It was very eye-opening for me to hear that type of discourse, that type of discourse on the legislature floor, right? On the Senate floor, to hear that kind of discourse, I was taken aback. And again, maybe naive. Maybe that type of stuff happens all the time. I expect that from people that have not been involved in these things. I expect that from people that are learning on the fly. Right. They're reading Google, or they're talking to their cousin's, third best friend who went through this.
Right.
So I get that sort of stuff, but having an elected official on the floor espouse that type of view in those statements was
painful.
It was rough. I want to say this. It was eye-opening, though. It was fun for me to be able to go and do that. I look forward to doing more of that, I think.
Well, and even after that exchange, too, the vote happened and it was passed.
Oh, yeah. It passed the Senate. It's, that particular bill, the three strikes bill, is actually going to go to the House. And so we'll see how that goes. But it was fun. It was a lot of fun. I enjoyed being at the legislature and doing it. Did you?
Yeah, it was a lot of fun.
Good. It's interesting to see how, the laws are made and then they're put into place. They put them in the book because they thought they were important. And then how we use them in court and how judges interpret them and then apply them to cases.
You want to hear something a little embarrassing?
Yeah.
So as soon as it got voted on, it passed the Senate. In my head, I thought, okay, so what's next? And all I could see was the little bill sitting on Capitol Hill.
Yes.
And I immediately thought my entire life has led to this moment.
Yes. All of those social studies that we had to do.
It is how it happens.
It is. This is actually how it happens.
It was great.
No, I agree.
But big shout out to Senator Paxton for sponsoring the bill, and to Robert Garza for his countless hours put into supporting all things family law.
No, yeah, he's doing a great job. He's, like I said, he's passed the time taken, time given back, and now he's working on three strikes. It's amazing. He's got a lot more coming down the line. So
yeah, he's an amazing human.
He is. All right, you good?
I'm good.
Let's get out of here.
Okay.
You want to? Guys, thanks for hanging out with us today. That is episode 25 here at Cases and Cocktails. Be sure to hang out with us next week for episode 26.
Be sure to like, share, and subscribe. We'll see you next Friday.